Hello, my name is Nick, and I'm going to give you some tips whether you are a petitioner or a respondent for a civil harassment restraining order. Now, what I'm going to be basing my advice on is the Judicial Bench Guide for California. And this is in the Judicial Bench Guide for orders prohibiting civil harassment in workplace post-secondary school violence. So there are a number of restraining orders that you can get in California. I'm going to be talking about civil harassment restraining orders today, and only those. So I'm going to skip over quite a bit of this bench guide, and if you are responding to a domestic violence restraining order or one that was issued against you to keep away from post-secondary schools, that's a different type of restraining order. What I'm talking about today is only civil harassment. So generally, these don't include any kind of violence, threats of violence. These are frequently between former friends, family members, neighbors, landlord-tenant. And if you are the responding party, then you need to pay special attention to this, because the consequences to you are probably more severe if this gets granted against you than the consequences to the petitioner if they receive an adverse judgment, meaning the restraining order is not granted in their favor after the temporary restraining order. So real quick, the way this is going to be structured is I'm skipping over all the preliminary steps of how to file a restraining order, how to serve. Okay, that's different. That's for a different video maybe. But today I'm talking about after that temporary restraining order has been issued, what is going to happen at your hearing. And at the hearing, the judge or the commissioner is going to decide, are there grounds to turn this temporary restraining order into a permanent one? And a permanent one doesn't mean forever, it usually means 5 years. And at the hearing, both parties will be present, they should be, either in person or increasingly virtual through MS Teams or Zoom. And it's incredibly important, especially if you are the responding party, which is called the respondent, to make sure that any evidence that you're going to present is well prepared, well tabbed, well indexed. I recommend that you create 3 copies of each. So you have a copy for yourself, copy for the opposing party, copy for the judge, and that you have ideally a 3-ring binder where all the exhibits are in your binder, either in page holders, which is a lot of work to do that 3 times, or 3 holes, you just put them in the binder. You have a tab on each exhibit, such as A, B, C, D, E, and then you have a table of contents at the beginning that says what each exhibit is. So A, description, photos of backyard. B, photos of allegedly damaged bicycle, etc. And copies of emails, those are also exhibits. But the point is you want that judge, that commissioner, to be able to access the exhibit that you're referencing as seamlessly and effortlessly as possible. So, in order for the petitioner, the person bringing the request for the restraining order, to prove harassment, they will need to either show unlawful violence, a credible threat of violence, or a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person, and that shows or serves no legitimate purpose. So there's a lot within that element. There's a lot of elements within that element. And we're just talking about harassment at this stage. So this is why you can't just go into court with your expectation of saying, oh man, everything the petitioner is saying is so ridiculous. Like, they have no evidence. This is so stupid. Like, I don't even need to be here. And that sounds like, who would ever do that? That sounds stupid. It happens all the time. People going in, they're cocky. They think that they can just easily just convince the judge like it's, a buddy, like a drinking buddy. Like, oh man, like just take my word for it. This person is just full of crap. Well, the problem with that, without providing any substantive evidence, is that the other party is probably going to do that too. But they're probably going to be a little bit better prepared. One party is going to be better prepared than the other. And one party is going to have the evidence on their side more than the other. And with a CHRO hearing, and in this case, the restraining order hearing, the permanent restraining order hearing, I'm only talking about the permanent restraining order hearing, right? The TRO is pretty easy to get. That lasts usually no more than 25 days, maybe a month at most, unless it's been delayed. What I'm talking about is the actual hearing, where the judge decides, do I let this thing expire, or do I turn this into a permanent restraining order, possibly for the next 5 years? And the consequences to that are severe for some people. You might have to give up your guns if you haven't already, because you're probably supposed to, either under the restraining order, or if you, for whatever reason, got a gun since then, you definitely have to give it up if this restraining order turns permanent, if you are the enjoined party, the restrained party, the party that is being restrained, from the petitioner. There's also immigration consequences. I've seen this, where the USCIS will postpone someone's immigration hearing, their naturalization hearing, because there's an active injunction against them. There's a civil harassment restraining order or a domestic violence restraining order. Okay, these are serious things that will affect you. So don't just think that, like, I'll never talk to this person again. I'm moving out. I'm never going to talk to this landlord again. I don't care if they have a restraining order against me. You should care, even if you never have intention of having any further relations with the protected party. So if you are the petitioner, you need to prove that the harassment was either unlawful violence, credible threat of violence, or the third one. And you can see on the screen how many elements there are to that. And if you are the respondent, then you have multiple pins to knock down. And if you've knocked down most of them, then you're probably clear to move on to the next. So if these are all standing, these virtual pins, then you haven't overcome that element. You better make sure you overcome the next few. But here, there's a lot of easy pickings to pick off if you're the responding party. For example, did it serve a legitimate purpose? If what you were doing as the respondent, as the restrained party, if that was legitimate, because maybe you were a tenant and you were voicing your discontent to the landlord because the water was leaking or the toilet wasn't fixed, and the landlord said, stop bothering me, stop calling me, that might be considered harassment, but it's not unlawful harassment. You're annoying the person, you're harassing the person, but it serves a legitimate purpose. I would argue it's not even harassment, but they're going to argue that it was. But are they going to argue that it serves no legitimate purpose? Is having a working appliance in the unit that you're renting a legitimate interest, meaning it serves a legitimate purpose if you're complaining about it not working? So if the conduct the petitioner is complaining about does not meet this definition, the conduct is not harassment for the purposes of a civil harassment order. So maybe that's an all stop. Maybe you've overcome that burden of proof as a respondent by showing this does not amount to harassment, no need to proceed to step 2. But maybe it's a wobbler, maybe the petitioner wins on that. So you can still dissect it further before you move on to the next set of elements. And what the book is saying, this judicial bench guide, is if the conduct the petitioner is complaining about is not violence or credible threat of violence, then the respondent's conduct must be knowing and willful to be harassment. So maybe the conduct is knowing and willful because you're blasting the music directly at the person. Maybe it's just inadvertent. You're just playing the music. It's not knowing and willful. I didn't even realize what I was doing. I'm sorry. And that'll be evidenced. That'll be shown through the facts. So the conduct about which the petitioner complains about must be directed at a specific individual, that is the petitioner, before the conduct may be considered to be actionable civil harassment. If the conduct is not directed toward the petitioner, but rather toward a group, organization, or location, then the petitioner may not be able to prove civil harassment. So if you're just blasting the music to all the other tenants out your window, that's not directed at any one individual. That's not directed at the petitioner itself. Even the petitioner will probably argue that it was. No, that's just to the world. You're pissing off everybody, not angering just that one person. But if that petitioner can show that it was directed towards that petitioner alone, and it served no legitimate purpose, so you are next door neighbors, you're aiming your speakers right at that person, they've asked you to stop, and your answer was anything other than, oh, I'm sorry, I won't do that again, that could be harassment. So just because the petitioner says it's harassment, there are many situations where it's still legitimate. And if it is legitimate, such as when you're a tenant, that is not something that entitles the petitioner to relief. because that serves a legitimate purpose. Therefore, it's not harassment. So, next. The statute also requires the petitioner to show that the conduct would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress to the petitioner. So this is two prongs. First, from a reasonable person standpoint, would the average person find that the respondent's conduct was such that it caused substantial emotional distress to a reasonable person, a normal person, this imaginary average person out in society? Would they find this to be substantially emotionally distressing? Would you, would I, would the judge? But if that is the case, did the petitioner actually suffer substantial emotional distress? So this two-pronged test, the first is hypothetical. Would a reasonable person suffer substantial emotional distress? And if the answer is yes, then the second part is literal. Did that petitioner actually suffer substantial emotional distress? And yeah, they'll probably say they did, but what are the symptoms? What are the manifestations? What's the evidence? Did they have to go to therapy? Did they lose sleep? How do they demonstrate that? That's harder than it seems to be on the surface. So the legislature recognized that there are going to be cases where the petitioner is distressed, but a reasonable person under the circumstances would not be substantially emotionally distressed. And this, under the law, would basically be known as the eggshell plaintiff rule. And in this case, the eggshell petitioner rule. And what that means is just because that petitioner was incensed, was substantially emotionally distressed, that person was hypersensitive. That doesn't mean that a reasonable person would, so that doesn't meet the threshold. You don't get special treatment under the law because you are hypersensitive. So there are times when family members get very upset with each other, but a petitioner might not get relief even though he or she may be very distressed. And what it's saying here is that, especially with family matters, the sensitivity is heightened. So just because someone is crying and hysterical, even in court, doesn't mean that the behavior from a reasonable person's standpoint caused substantial emotional distress. So they have to meet both. Just because that person did, in fact, suffer substantial emotional distress, well, that's element 2. But element 1 was, yeah, but that behavior, saying that you keep eating turkey sandwiches and you have no concern for turkeys, that is not something the average normal person would be substantially emotionally distressed about. So just because your sister is a vegan and breaks down every time you tell her how much you love turkey sandwiches for lunch doesn't mean a reasonable person would. Therefore, that threshold has not been met. So course of conduct. And no, the bench guide does not specifically reference turkey sandwiches. So course of conduct. The course of conduct element means that the respondent has engaged in a pattern of conduct composed of a series of acts over a period of time, however short, that shows a continuity of purpose. So this is requiring that in order for the petitioner to have relief, and we're not talking about violence or any credible threats of violence here, we're just showing course of conduct, civil harassment, and even a one-time nonviolent incident is not sufficient for a civil harassment order because the petitioner has failed to prove a pattern of conduct over time. So if the petitioner is showing how egregious this person was with blasting their music, it wasn't repeated. It was on the quinceanera. It was on the bar mitzvah. It wasn't every week. You don't have a bar mitzvah every single Friday. Usually, unless you live next door to a synagogue maybe. But the point is, it has to be repeated over and over. And remember the previous elements, like directed at the petitioner, no legitimate purpose, causing substantial emotional distress to a reasonable person, and did in fact cause substantial emotional distress. Right? So you're piling on these elements, and you're seeing that the petitioner's case is getting more and more difficult, which directly and inversely correlates to how easy it is for the respondent to disprove, because it's up to the petitioner to provide the evidence to meet all these elements, and you as a respondent, especially as respondent's counsel, should be reminding the judge as gently and respectfully as possible that this course of conduct element wasn't met. This directed at a particular person element wasn't met. This served a legitimate purpose. All right, so that's your best hope rather than just saying no. So you cannot properly take away the property and due process rights of a person by ordering him or her out of an apartment he or she rents from the petitioner or landlord. The petitioner's remedy in such a case is to file an unlawful detainer proceeding to terminate the tenancy without the tenant's consent. That means don't use the restraining order process to substitute for an unlawful detainer. What's an unlawful detainer? In California, an unlawful detainer is how you get rid of a tenant lawfully through the courts to get a writ of possession, which shows that you are entitled to regain possession of the leased property, whether it's month to month or a lease, and the sheriff and only the police, usually sheriff, can lock out that tenant. You cannot do it yourself. You cannot use self-help in California. You cannot just change the locks. You have to go through the court process to get an eviction. And that process is called an unlawful detainer. And if you're successful, then you get an eviction awarded in your favor against your tenant. And that is how you get rid of them. But what people do is they use the restraining order process and they try to get an injunction against a roommate, against a tenant, against a child that lives in their house. You can't just do that. And even though people do it all the time, well, people drive drunk all the time. You don't get a waiver after the 1 millionth person is driven drunk. It doesn't mean the law is not able to be enforced just because people do this all the time and they're wrong. So, burden of proof. This is important. Everything else is important too, but this is very important. You need to understand what your burden of proof is if you are the petitioner in a civil harassment restraining order hearing. The burden of proof for these hearings is lower than the criminal standard of beyond reasonable doubt, but it's higher than what you'd see in, for example, small claims. So, petitions for an order to prohibit civil harassment do not have the normal civil burden of proof. The normal civil burden of proof is a preponderance of the evidence. So, preponderance of the evidence for normal civil matters, for small claims, means that if you are the plaintiff, you have to meet your case by 51% burden or better. If you don't, and it's exactly 50% both ways, the judge shall rule in favor of the defendant. You have not met your burden to show a preponderance of the evidence. And again, that's for the civil standard. But it's higher for this one. It's higher for your civil harassment restraining order hearing. So, in civil harassment cases, a judge cannot grant an order unless the petitioner proves his or her case by clear and convincing evidence. That is what you need to remember. Clear and convincing evidence. CCE, clear and convincing evidence. All right, so restraining order means CCE, clear and convincing evidence. And that is one of the areas of law that is sloppy. It sounds neat and tidy on the surface, but when you actually try to understand, okay, so what is clear and convincing evidence? Where does that start? That's where it gets messy. And what I can say is that it's higher than normal civil standard for preponderance of evidence, but it's lower than the criminal standard of beyond reasonable doubt. And the judges who author these bench guides say that if the sole evidence of alleged threats by the respondent is the petitioner's statement under oath that the threats were made, but the respondent under oath denies making these threats and there are no corroborating witnesses or any corroborating evidence, then it's unlikely that the judge should find that the petitioner's case has been proved by clear and convincing evidence. So remember, in a small claims court, if both sides provide equally compelling arguments, the defendant wins. In this case, if the petitioner provides, a little bit better of an argument, but still the evidence is pretty much equal, and the petitioner says, you made these threats, and the respondent says, no, I didn't, and there's no evidence to tip the favor in the petitioner's favor, then the judge should rule, it's not a shall, but it's a should rule in favor of the respondent. So that concludes everything I wanted to say about restraining orders, civil harassment restraining orders. There's all kinds of California codes of civil procedure, and it's worth emphasizing because I touched on this briefly. When you present in court, there are pretty much three things that you can do to give yourself sometimes an unfair advantage, because the other side rarely does this in many cases. Oftentimes, both sides don't do this. One, have your exhibits neatly labeled. Have tabs on each one, and then have a table of contents at the beginning like an index that explains what each exhibit is. So everything should be tabbed, like A, B, C, D, E. All your pictures have a tab. All your email printouts have a tab. All the contracts have a tab. And at the beginning, you have a table of contents that explains what each tab is. And that goes in, ideally, a 3-ring binder. You can do the 3-hole punch, these pages, put it in the binder, or put them in sheet protectors so they're easy to remove. But you want 3 copies, one for yourself, one for the opposing party, one for the judge. You want to make it as easy and seamless as possible for the judge to reference what you're referring to be able to put eyes on if it's a printout, and not waste the judge's time, because it is fleeting, it is sacred, and that's why my second point is always refer to the judge or commissioner as Your Honor. Yes, Your Honor. No, Your Honor. You want to say Your Honor so many times that it sounds redundant. And if they ask you a yes or no question, don't make the answer so professor-like. Just say yes, Your Honor. No, Your Honor. People love to not answer yes or no questions, but give this elongated, obtuse, obfuscating answer that just buries the point. If you have a great point, don't dilute it with extraneous details. If you have a perfect piece of meat, don't bury it in salt. You want to present the meat of your argument as succinctly and directly as possible, like on a plate with nothing else, just focused to the point. So those are my obvious tips that unfortunately are not so obvious. Go for the low-hanging fruit. Give yourself an unfair advantage. Give yourself all the chances to put everything that's within your control in your control, because there's going to be a hell of a lot more that is out of your control. I hope you never need this, but if you do, I hope you find this helpful.